And yes, we got great news to share with you. In this video, we are going to be talking about, first of all, the latest in immigration news, and we are going to be talking about this case where my client finally got an approval, right, of an expedited request on an asylum petition, the form I-589, pending with USCIS for about 8 years. I'm going to talk to you about how we went about it to actually get this approval. But before we get into it, please go ahead and share, like, subscribe. Don't forget to comment below. And also, if you need a consultation with me, consultation link is in the description box below. You can also follow us on all platforms. We have TikTok, Instagram, Facebook page, Facebook group, and also Thread. If you're not actually following me on Threads, you are missing out because we are updating you on all the latest immigration news. Let's start with news number one, okay? The Fourth Circuit Court yesterday, pretty much July 12th, decided, ruled that petitioners with a defective notice to appear are entitled to rescission. It simply means that if you have a notice to appear that was defective and because of it you were ordered removed in absentia, meaning that you were not there where they enter. So basically they enter an order of removal, but you were not physically there, present, okay? Based on the fact that you missed that notice to appear, you never received it, because it was defective. So, and even if you received it, the fact that it was simply defective, you are entitled to rescission. You can terminate your removal proceedings, and if you have a claim of a cancellation of removal, you can also go ahead and just file it, okay? This is really like the Fourth Circuit following along with other circuits. And if you have been following me, you know that we've talked about Chavez versus Garland. It's pretty much similar, right? The effective notice to appear is when you receive a notice that lacks the time, the place, the date of the hearing. Sometimes it just lacks the time and the date. And it says to be determined, TBD, while that notice is defective. The immigration court or DHS is mandated to give you to serve you properly, to give you a proper notice, okay? The first time, not the second time, the first time. So if you notice to appear as defective, you're here in the Fourth Circuit. Even if you are not in the Fourth Circuit, my friend, we are just gonna take this law and persuade other circuit and reopen your case, terminate removal proceedings, and as a matter of fact, if you qualify for cancellation of removal, we're gonna cancel that removal altogether. My friend, this is great news. This is a big deal. How do you assess that, right? If you wanna do your own self-assessment case, look at your first notice to appear. Look at it. If the notice lacks the time, the date of the hearing, the first notice that was provided to you, if it lacks the time and the date of the hearing, it is defective. It doesn't matter if they come with the second notice, okay? So, and if you were ordered removed in absentia, because if you physically showed there, so it means that you actually conceded, right? But if you were ordered in absentia because you were not there, you failed to be notified, they failed to notify you properly, you never receive proper service, my friend, you can reopen your case, terminate removal proceedings, and if under your circumstances you qualify for cancellation of removal, go ahead and apply for it, okay? If you need, for this one, my friend, you're gonna need counsel. If you do not have one, I strongly suggest that you click the link in the description box below so we can access your case and we're gonna let you know which path to follow, okay? That's good news number one. Good news number two is that, well, you can actually, if you have an online account, right? USCIS online account, and you file a form I-765 I-131, you can follow the progress of it. My progress. USCIS has extended their services to those two forms as well. Usually they do it for I-90 and I believe I-485 as well. So yes, they have, you can follow the progress, so you will know how long they still have until they decide your case. That's good, at least to know, right? So that's a good news. What else we have here, my friend? We have this case that we just got an approval yesterday. Okay, 8 years ago, this client came to the United States because he was fleeing persecution from the country of origin and applied for asylum, but they never called him, just like anybody here, right, who has the asylum pending for 8, 9 years and up, even 7 years ago. They never called him. So he has been trying to figure out a way to get it done, right, to get to that interview. But everybody advised him against it. There's nothing you can do. You know, when you get advice in the streets, sometimes they don't know what they're doing. They just tell you there's nothing you can do. As a matter of fact, there's something you can try to do, right? You can't just sit there and wait. So he was ready. When he came to me, I advised him like this, the way I'd advise all the people with asylum pending with USCIS. I'm only going to take your case only if you agree that we are going to file a lawsuit to solve these unreasonable delays. And I only take cases that have been pending starting for 6 years and half, 7 years, 8 years and up. 5 years, I'm not going to take it because, yeah, you might get a dismissal in court because, you know, a lot of people are still waiting. But if it's 6 years and up, I'm taking that case of asylum pending for that long, okay? Told him, well, I'm going to take it only if you agree that we are going to go and file for a mandamus lawsuit. But before we go to file for a mandamus lawsuit, there are some procedures that we should follow in order for us to avoid a dismissal in federal court, because you're going to spend your money, you don't want a dismissal. So let's follow the procedures, right? What are those procedures? Only one procedure. You must exhaust all remedies, all administrative remedies. Meaning what? Meaning that you must have talked to USCIS, try to file expedite requests, try to involve anybody that you know that can talk to them on your behalf in order to find a solution, right? We filed expedited requests. He came on March 13. We filed expedited requests on March 13. We never received a response. On April, sometimes I just decided to go there to Arlington office to figure out what's going on, because we didn't even get a receipt showing that our name is actually there. I went there, I refiled the same thing, not like refiled, but I just make sure that I actually told them that I filed it on March 13. This proof that we filed it, we signed some paperwork there. We came back, nothing was working. We reach out to ombudsman office, and then we reach out simultaneously, right, to ombudsman office and to the congressman office to get them involved as well. So in May, June, nothing happened. We keep following up because we wanted to build the case, basically, to have all those proof. And I told him I'm just going to give them 4 months, because that's how I know how USCIS works with those expedited requests. You give them, especially for asylum, because they have a lot of cases, you give them 4 months. The court will give them 60 days. And in addition to that, if they actually try to continue the case, the court will allow them another 90 days. Oh, so another 30 days, which is going to make it 90 days. But I just wanted to give them sometimes, right? I say we're going to give them 4 months. If in 4 months we don't get a solution, we file a lawsuit, because at that point we have all the proof that we follow procedures. We have exhausted all administrative remedies. So we went ahead and actually did all that, and then yesterday we just got a response that they have agreed to actually expedite his case. Okay, now we're just waiting for the date of the interview. Well, in my personal experience, at that point, it's not going to take that much time to get the actual interview. It might take time, but we know that within 60 days, if they don't respond, we're going to follow up. We're going to follow up, and we're going to threaten them with a mandamus lawsuit, because they're the one who agreed to expedite the case. So they have to give us an interview date. So moral of the story is this: if you have a case pending with USCIS for too long, yeah, you need to take action. You can't just sit there and wait, okay? Especially if you have to reunite with your family. If you have all your family here, sometimes people really they don't care, just waiting until the day they're gonna call them, right, for that interview. But if you are intending to get your family from outside to get here, and you're just sitting there, and they're gonna sit there. Remember, they have this policy: first come, last to be served. They have been interviewing people from 2018-19, but people who applied earlier, like in 2014-15, they never actually called them, a lot of them. Well, so the solution is try expedite a request. If it doesn't work, you just file a mandamus lawsuit and get this thing settled once and for all. If you follow all those procedures, chances are really the federal court is going to mandate USCIS to actually schedule an interview for you. They're not going to dictate the outcome of the case, but at least you're going to get your interview. That's the least a mandamus lawsuit can do. The mandamus lawsuit can do it in other areas too. It's just not for asylum, but for some other cases too, pending for too long. Yes, you can use that venue to find a solution. My friend, this is great news. We have great news. We had great news yesterday. We're just so in the mood of receiving great news. We are awaiting other great news. If you need the consultation again, please go ahead and schedule it by using the consultation link in the description box below. Until next time, bye-bye.